An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman. Tinker versus Des Moines Independent Community School District, 1969. In 1965, the United States was involved in a military conflict with Vietnam. However, the Vietnam War was very unpopular. In Des Moines, Iowa, several students planned to wear black armbands in school to protest the war. The armbands were intended to express support for a ceasefire and to mourn those who died. The school district adopted a policy to prevent this protest. The lawyer for the school district explained,
"To maintain discipline and avoid disruption, the wearing of the armbands in the schoolroom should not be permitted."
At the time,
Debate over the Vietnam War had become vehement.
the lawyer recounted that
A protest march against the war had recently been held in Washington, D.C. A wave of draft card burning incidents protesting the war had swept the country.
Study Guide. United States versus O'Brien, 1968, held that the government could criminalize draft card burning. Was armband wearing a form of, quote, symbolic speech, like draft card burning? Or was armband wearing a form of, quote, pure speech? In violation of the new rule, 3 students wore black armbands to school.
Christopher Eckhart, who was 16 in the 10th grade, John Tinker, who was 15 and in the 11th grade, Mary Beth Tinker, who was 13 and in the 8th grade.
The student's lawyer explained that,
in spite of the policy that had been announced through the schools that they would wear the armbands as a matter of conscience to express the views that they had. Mary Beth Tinker also wore her armband on that first day. However, she wore it throughout the entire morning without any incident related to it that in any way disrupted the school or distracted.
however, during her first afternoon class, Mary Beth was called to the principal's office and was asked to remove her armband. The lawyer acknowledged that Mary Beth
Did remove the armband and then returned to class.
still, even though Mary Beth removed the armband,
She was later called out of class and suspended nevertheless.
John Tinker and Christopher Eckhart were also
Sent home, would be in effect suspended from school until such time as they were willing to return to school without the armbands.
The students sued the school district. They argued that the armband prohibition violated their freedom of speech. The trial court ruled that the prohibition was a reasonable means to, quote, prevent disturbance of school discipline. The students appealed the case to the United States Supreme Court. During oral argument, several justices seemed worried that the armbands could distract other students from learning. Justice White asked if students were
supposed to be taking in this message about Vietnam while they're studying arithmetic or mathematics.
Chief Justice Warren inquired whether
The principal could prevent the use of
black armbands if they
started fistfights or something of that kind and disrupted the school.
In response to these questions, the student's lawyer proposed a test.
A material and substantial disruption to the schools would justify perhaps the subordination of freedom of expression.
Justice Fortas seemed to agree with this test. He suggested that the students could be punished if
The wearing of the armbands significantly or substantially or materially interfered with the business of the classroom, that is, communication between teachers and students.
the Supreme Court ruled for the students by a 7-2 vote. Justice Fortas wrote the majority opinion, which had three primary parts. First, the court ruled that both teachers and students have First Amendment rights. They do not, quote, shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Study guide. Does the Supreme Court explain why students have free speech rights in public schools? In Morse v. Frederick, 2007, Justice Thomas wrote that, quote, the history of public education suggests that the First Amendment, as originally understood, does not protect student speech in public schools. Second, Justice Fortas adopted the test proposed by the student's lawyer. The school can only restrict a student's speech when that speech would, quote, materially disrupt classwork or involve substantial disorder or invasion of the rights of others. The school cannot restrict speech merely, quote, to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. Study guide. How should a court determine if a disruption is, quote, material, or if a disorder is, quote, substantial? Third, in this case, the armbands did not materially disrupt school operations. There was, quote, no indication that the work of the schools or any class was disrupted. At most, Tinker and the other students, quote, caused discussion outside of the classrooms, but did not cause any, quote, interference with work in the classrooms. Rather, quote, the school officials banned and sought to punish the students for a silent, passive expression of opinion. Here, the schools had, quote, an urgent wish to avoid the controversy which might result from the expression, even by the silent symbol of armbands, of opposition to the Vietnam War. In the end, the court ruled for Christopher Eckhart, Mary Beth Tinker, and John Tinker. Justice Black wrote the principal dissent. In his view, the armbands, quote, did divert students' minds from their regular lessons. For example, a math teacher said that Mary Beth Tinker's demonstration wrecked his lesson, and other students taunted Tinker and her classmates. Thus, even under the majority's test, the armbands could have been banned. In any event, Justice Black contended that it was not the Supreme Court's role to decide whether a government policy was unreasonable. There was a time, Black recalled, when the constitutional test of reasonableness prevailed on the Supreme Court. During the so-called Lochner era, courts would declare, quote, laws unconstitutional when they believed the legislature had acted unwisely. For example, Lochner v. New York, 1905, held that a maximum hour labor law was, quote, an unreasonable, unnecessary, and arbitrary interference with liberty. And Meyer v. Nebraska, 1923, held that a law prohibiting the teaching of German in schools was, quote, arbitrary or without reasonable relation to some purpose within the competency of the state to effect. This approach to the Due Process Clause proved controversial. Indeed, Justice Black contended that the reasonableness test, quote, brought on President Franklin Roosevelt's well-known court fight. However, during and after the New Deal, the Supreme Court changed course. And in time, the Supreme Court, quote, discarded the doctrine that prevailed in Lochner. Yet, Black wrote, the Tinker decision apparently, quote, resurrected that old reasonableness due process test. Black lamented that, quote, it will be a sad day for the country when the present-day court returns to the Lochner-era due process concept. Study guide. Justice Black equated the standards from Lochner and Meyer with merely deciding if a law was, quote, unwise. But these cases considered if a law was, quote, unreasonable, unnecessary, arbitrary, or lacked a reasonable relation to some purpose within the competency of the state to effect. Is Justice Black's characterization fair? The majority did not disagree with Justice Black's critique. During oral argument, Justice Fortas asked the school district's lawyer,
"What do you do with Myers against Nebraska?"
Fortas said that Meyer
Present very serious obstacles.
for the school district. Fortas seemed to recognize the broad sweep of Meyer and the reasonableness test. If the armband regulation is,
So unreasonable.
Fortas said, then
It's a violation of the Due Process Clause of the 14th Amendment.
with that finding, the Supreme Court can,
Tell the school board what it can or cannot do.
and by a vote of 7-2, the Supreme Court told the school board what it could not do. Study guide. Meyer v. Nebraska held that the ban on teaching German violated the Due Process Clause of the 14th Amendment because it infringed on the liberties of the school and of the parents. At that time, the Free Speech Clause of the First Amendment had not yet been incorporated into the Due Process Clause of the 14th Amendment. Was Meyer a substantive due process case or a First Amendment case? Did Tinker also involve the 14th Amendment? Justice Black's dissent concluded that, quote, uncontrolled and uncontrollable liberty is an enemy to domestic peace. He warned that, quote, young, immature students will likely soon believe it is their right to control the schools, rather than the right of the state that collect the taxes to hire the teachers for the benefit of the pupils. Study guide. Did Justice Black's warning prove to be accurate? Today, Tinker remains good law. The Supreme Court reaffirmed this precedent in Mahanoy Area School District versus BL, 2021. This case held that a school could not punish a student for posting to social media while off campus. The student's Snapchat posts did not cause, quote, the sort of substantial disruption of a school activity, or he threatened harm to the rights of others that might justify the school's disciplinary action. Study guide. Can you distinguish Mahanoy from Tinker? Hint, doesn't matter where the student engaged in speech.